This is TWiT.
Naruto versus Slater, the formal name of this case, was argued before the Ninth Circuit Court of Appeal in San Francisco this Wednesday. And much hilarity ensued. It was the end of the morning docket. It was a case where many, many questions were asked to the PETA lawyers that seemed to indicate perhaps that the Ninth Circuit was leaning toward the direction the Copyright Office has gone. The Copyright Office has explicitly said that animals cannot hold copyrights, in its esteemed opinion. The Copyright Office's opinion, though, is not binding necessarily on the Ninth Circuit Court of Appeals or on Congress or any other law-making body. It's just how the Copyright Office has said it's going to treat the copyright analysis for animals. So for a little background on people who may not have been following this case that closely, several years ago, a photographer named David Slater was in Indonesia, and he was photographing some macaques. And I'm not sure how his camera equipment got left where the macaques could pick it up, but one of them did and snapped the now famous photo that, if you're watching our video, you are seeing, of the grinning macaque Naruto. Now, I'm going to put an asterisk when I say that this is a photograph of Naruto, because that is not necessarily something that we know for sure. And that's actually possibly an issue in the case. So we'll bookmark that and come back to it in a moment. In any event, a monkey, a primate for sure, a macaque, took the photo that you were looking at. We're not sure if it was Naruto. And the photograph wound up on Wikimedia Commons, under the theory, per Wikimedia Commons, that a primate cannot hold the copyright to a photo that it took. And if the primate doesn't hold the copyright, the primate as photographer is the only person that could hold the copyright. So David Slater does not, the person who owned the camera equipment. And so, ergo, the photo must be in the public domain. David Slater didn't agree with that and went on to publish a book himself and to collaborate with self-publishing platform Blurb. I don't know if you've used Blurb before. I certainly have. It's somewhere where you can go and upload your photos and format them into a nice little book. And that's what David Slater did. So there is a book available on Blurb to this day that is a collection of David Slater's photographs of animals. The macaque is on the cover. It's called Wildlife Personalities. It features various other animals that he has photographed on the inside. So, at least one of which, there is another monkey in here that has arms out in front of it that may have taken, that one right there on the left if you're watching the video, that may have taken the selfie of itself. I don't know if the other macaque there featured. We can't tell if that's a photo that was taken by the monkey itself or by David Slater. But in any event, he has this nice collection of photos that he and Blurb are profiting from, if anybody buys this book from the Blurb site. Enter PETA, the People for the Ethical Treatment of Animals, who have come in and sued over this book on behalf of, and as what's called a next friend of, the animal who they claim is Naruto, who took the photograph that went viral and became famous. So this litigation has been pending for a while. We've been chuckling at it for a while, and it was just argued before the Ninth Circuit. And within a couple, 3 months, we will have their decision on whether PETA can sue in the place of the animal to assert what it claims are the animal's copyrights. Some interesting notes from the oral argument. The issue of which macaque it is did come up. The panel was grilling the PETA lawyer on whether they would have standing to sue on behalf of an animal that they have not named, because apparently one of the scientists who had worked with these macaques and was involved in working with PETA in the litigation for a while, but had a falling out with them, claims to know, and would be the kind of person who would know, that the person, one of the photos is not actually of Naruto. And that PETA may have named the wrong animal, maybe purporting to represent the wrong animal. Hence was born, as Sarah Jong calls it, the monkey truther movement. People trying to get to the bottom of which monkey is actually in the photograph. So we had that going on at the oral argument. There was also a lovely exchange about... and let me see if I can actually find it here and read you some of the text from the argument. Sarah Zhang watched it live and wrote it up for Motherboard. The statute, the blurb attorney at one point pointed out that the statute refers to sending out written notice of a copyright lawsuit to anyone else who has or claims an interest in the same copyright. So she says, it makes no sense to allow a monkey to enforce a copyright suit. But if you're going to do that, it's equally absurd to deny a monkey written notice of a right to intervene in a lawsuit. And then one of the judges interrupted and said, well, Naruto wouldn't need written notice. Maybe the other macaque monkeys in Indonesia would, at which point the courtroom burst into laughter, as we all can too, pondering the notion of how perhaps one would give notice to a macaque. Maybe it would have to be done in emoji form, Gabby.
Maybe the monkey see, monkey do not hear.
Yes. And then a gavel and the scales of justice.
The camera, the photo emoji, absolutely.
Mm-hmm. So that all happened this week, and we are just so thrilled. Sarah and others seem to think that PETA does not have a shot here, but rather than just say that and say, as the Copyright Office did, that animals can't hold copyrights and this is a ridiculous case and we must move on. I think this case goes further than that, right? It's what has rights and what rights do things have that are not human? And I think that starts to become a really interesting question when we start to consider works created by AI, which are becoming more and more common. So, Mike, now that we've sort of put this all on the table for people, what are your impressions?
Boy, where do I begin?
Yes.
I have so many thoughts on this case. I will say that I was listening to the oral argument on YouTube and found it to be quite amusing. I particularly liked David Slater's counsel opening line of argument was something like, monkey see, monkey sue should not be the law in the Ninth Circuit. We've talked about this before. I think the result is obvious. I'm not really making a wild prediction here that the Ninth Circuit is most likely going to at least affirm the decision. There's an open issue, I think, as to whether the defendants are entitled to attorney's fees under Section 505, and Slater's attorney asked for this case to be remanded, at least for that determination, as far as the amount was concerned. So, I mean, look, under the copyright statute, as we've discussed before, there's absolutely no indication that Congress ever thought that a monkey or an animal or a non-human could be an author for purposes of copyright law. I think the result is going to be obvious here. I would be beyond stunned if this case goes any further than it's gone thus far. But to your point, Denise, I think what really is the interesting issue here, and this is something that's ultimately going to have to be resolved at the congressional level as opposed to through the judiciary, is what do we do with works of authorship that are clearly being created by artificial intelligence? Paintings, music, all of that would clearly satisfy the requirement for originality and creativity when it comes to a work of authorship under the Copyright Act. And I'm just not certain, I'm not convinced that there's an answer. I think as the statute reads right now, those works wouldn't be subject to copyright protection because they're not authored by a human being. But I think this is ultimately going to have to be an issue that's addressed. As silly as this PETA case is, in my opinion, it does kind of forecast or look forward to this other issue that is much more meaningful and much more important, which is, can artificial beings that are created by humans create works of authorship? And I think the answer's got to be yes, and that's going to have to be addressed by Congress in some form or fashion. So those are just some of my thoughts.
Right. And in other countries, works created by computer, whether artificially intelligent or not, I guess self-directed at least would be the criteria here. They're not being considered created by a human. They're being considered created by a computer. In the UK and in other countries like Ireland and New Zealand, those works do have copyright, but it belongs to the person who made the arrangements to have that creative work made. So that's one approach. And then on the other extreme, there are countries like Spain and Germany that specifically say that only works created by a human can be subject to copyright protection. So, here in the US, we seem to be straddling the fence on what we think AI created works, where we think they fall on that protection spectrum. And, PETA does make the point, or it tries to, this was argued back at the district court in 2016, that, the point that you raised, Mike, is that when the Copyright Act was written, and even going back to when, the Constitution was written, which is the basis for the Copyright Act, that nobody involved in that process was thinking about copyrights for anything other than humans. But PETA is casting this as, okay, well, the law evolves and things have changed since we first established the principles that now are the law of our land. For example, they make the point that the judges just can't assume that persons under the Copyright Act have to mean human beings because, at one point or another, marriage was only between a man and a woman, and we've evolved away from that approach as far as the law is concerned. And PETA argues that actually giving the animal rights here, regardless of whether they can establish they have the right animal. That, by the way, is one possible outcome here, is the court just sort of punts and says, you haven't established that, the animal you've sued on behalf of is the animal in the photo. And until you do that, go away and come back when you've got that T crossed. So that would be one way to not reach the merits here. But in reaching the merits, PETA has said that if the court does grant PETA the ability to act on behalf of these animals, that it's a step forward, acknowledging that things have changed, much like, what is marriage? They have, here's Sarah Zhang's characterization. She writes, speaking of PETA's attorney, he also said at the time that Naruto's supposed inability to own a copyright was analogous to an enslaved African American's inability to own a patent prior to the adoption of the 14th Amendment. Whether these analogies make a convincing case for animal rights or are actually wildly offensive, I will leave as an exercise to the reader. So there is, if we're going to be establishing that creative works by a computer are protectable, and maybe ultimately that a computer has some sort of awareness and agency and a right to some sort of personhood status, then doesn't it seem unfair that animals aren't at least in the running for that kind of consideration? What do you think, Matt?
I don't think it's about fairness. I think that you have to think about like what is the purpose of our laws designed for, and you know the slave issue is something that like the laws were designed not to protect slaves, and therefore they didn't have standing to sue. And that was a terrible time in our history, and that's something we've moved on from. But ultimately, like, you know, the philosophical reason that we moved on from that was because slaves were people, and we acknowledge that. I don't think that we're ever going to get to a time where an animal is a person or has the same dignity as a person, and I'm not sure that we'll ever get that way with computers. I think that there's other ways to go about getting copyrights for this as an extension of a person who owns a computer, of an extension of someone who wrote the computer code that eventually wrote the computer code. And that kind of sounds like what the other countries are actually doing. That they're not independently giving a computer the right to own it. They're giving a person who owns the computer, who wrote the code, the copyright ownership. Which I think is, you know, just as a philosophical reason, like, you know, you can look at the world and see, and I'm pretty sure this is how PETA looks at the world, that organic life is the same and humans aren't better or any way different. I don't think that's the approach that the law takes, and I don't think that that's like a very effective way for human flourishing for the law to take.
Right. So, Gabby, let's assume for a moment that Sarah and other commentators are right, that the Ninth Circuit isn't going to give PETA the right to assert copyrights on behalf of the subject of the photo here, assuming they've got the right subject. Hashtag monkey truthers. Let's assume they're right. Should that necessarily mean that David Slater then has the copyright or doesn't have the copyright? Maybe what our law should do is not take the approach that the Copyright Office has taken and that Wikimedia Commons took, that these would necessarily be public domain because no one could own the copyright. But maybe we should follow that UK approach with regard to things created by machines and say, okay, the photographer did not take the photo, but the fact that the photographer had the camera there, made the camera available to the animal who took the photo, means the photographer gets the copyright. What do you think about that?
It's a good question. And, you know, that would be the sensible approach here. I mean, to make a funny analogy, think about all of the young kids. I'm sure you've seen this on your friend's Facebook page or Instagram. Their child accidentally takes a selfie and they post it. Does the baby own it? Is the parent infringing by posting their child's picture? I mean, as silly as that sounds, it's a similar analogy of where we're going here. And so, you know, arguably, yeah, the parent can, of course, post that picture of their kid, or if someone were to use that. So in this situation with the monkey, you know, maybe we make it easier on those situations for those particular, I mean, the photographer is actually, I saw an article today complaining he's broke after this lawsuit. I mean, he was just doing his job and wanted to share his experiences, and now he's paying legal fees. And so, you know, maybe the solution is what you're suggesting, giving the right to the photographer. But, you know, also thinking about this, I'm going to take a step back, and I read a piece about how, okay, the corporation, for example, is not a person per se, and there's the back and forth with the Supreme Court making that decision. And, you know, maybe this was in the context of his work, and it was, you know, his camera that he used. So maybe there's an argument where in that unique situation where a non-human is involved, if it is your materials that were used, so your phone, your camera, whatever it was, in the course of your work, maybe, you would retain that copyright. And I think we're in this strange gray area where no matter how we come out with regard to can a monkey have these copyright rights, we have to look back to standing too. I was taking a look at some of the circuit law, and you had mentioned the issue of notice. And a lot of circuits have come out on strictly the issue of copyright ownership, that the claim for contesting copyright ownership accrues when the claimant has expressed notice that someone else is claiming ownership. And so I know there was the joke back and forth, but this is truly the law, whether you're a monkey or a person. You need to have received an express notice. So, I doubt the photographer sent a letter, like they said, to, Naruto, hey, I think this is mine. Simply publishing it's more of an implied notice. And so, that begs the question, as we have these laws, there's an expectation that you're going to check everything off so you truly have a claim accruing. And, PETA may have brought it prematurely and to guise it as copyright infringement versus, hey, we're just talking about copyright ownership here. Because in a traditional copyright infringement case, usually ownership is pretty clear and you move into the infringement factor. So I think, regardless of if you're a machine or an animal or a person, we have rules of law and you shouldn't be wasting the court's resources unless you've met those requirements for standing.